call the matter of ETV, Pty Limited and others, and Minister of Communications and Digital Technologies and others for hearing. Council are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you, Ms. Courtney.
May it please the court, I appear for ETV together with my learned friends, Mr. Duplessis, Mr. Kutsoudis, Ms. Paraffin-Jones and Ms. Moodley.
Thank you, Mr. Makas.
May it please you, Justices, I appear together with Ms. Harding-Moodek for MMA and SOS.
Thank you, Mr. Ferreira. We seem to have lost Mr. Mutau for the minister.
Yes, it seems so, Justice Mkandla. Whilst he's connecting, I appear for the second and the third respondent, ICASA respondents, together with my juniors, Mr. Majosi and Ms. Litole.
Thank you, Mr. Mukari.
While we're waiting for Mr. Mutau, may it please the court, together with my learned friends, Mr. Turner and Ms. Msimang, I appear for Vodacom.
Thank you, Mr. Sneakers.
Yes, may it please the court, together with my learned friends, Ms. Likokotla, Mr. Smith, and Ms. Dladla, I appear for the minister.
Thank you, Mr. Mutau.
As it please the court, Justices, I appear together with my learned friend, Mr. Janssen van Rensburg, for Centec, the 12th respondent.
Thank you. Thank you, Mr. Rousseau. Mr. Marcus?
Thank you, Justices. We propose to address 4 topics. First, we will address what we submit as the unjustifiable breach of Section 16 of the Constitution. Second, we will deal with the state's duties and promises regarding the provision of set-top boxes and the failure to fulfill those duties and promises. Third, we will deal with the minister's failure to consult with interested and affected parties. And last and briefly, we will deal with remedy. I have discussed a division of argument with my learned friend, Mr. Ferreira. He will, of course, speak for himself, but in broad terms, he will deal with the factual impact of the imminent switch off, the numbers affected, and the irrationality of the decisions, both substantively and procedurally. Can I then start with the breach of Section 16? Come the analog switch off, significant numbers of viewers will be cut off from analog television broadcasts. Those numbers are estimated to run into millions. Their rights to receive information and ideas will be severely limited. But the limitation we submit will go beyond limiting their freedom of expression, because as this court has recognized in many decisions, freedom of expression is a gateway to other rights. It is part of a web of mutually supporting rights. And that is of particular importance in the context of the present case, something which the minister appears to acknowledge. If one goes to the digital migration policy of 2008, which is Annexure PR 24, it's to be found in volume 3, and I'm going to refer to 2 passages on page 266. In paragraph 2.1.4 on that page, there is reference to accessibility to broadcasts as, and I quote, an important tool for societal and economic development, and as, and again I quote, essential to meet our poverty reduction goals. And on the same page in paragraph 2.2.3, it is recorded, and I quote, globally, poverty is associated with low access to information and knowledge. Government therefore regards greater information and communication flows within and between communities and regions as an important tool in the war against poverty in South Africa. But, says the minister and Vodacom, there is no real cause for concern. And they advance, in essence, three arguments to defeat the claim of an unjustifiable limitation of freedom of expression. First, they say there is no violation of the right at all. Second, they seek to insulate the minister's decision from effective constitutional scrutiny by labeling her decision as an executive decision. And third, they attempt to shift the blame by saying that the state put in place a reasonable mechanism for registration for set-top boxes, but they are not responsible for the poor uptake. Effectively, they say indigent individuals who have not registered have only themselves to blame. Let me deal with each of those defenses individually. As to the alleged absence of the breach of a right at all, our learned friends for the minister say in paragraph 91 of their heads that section 16(1)(b) does not guarantee access to a particular stream of information, such as free-to-air television. It merely ensures the freedom to receive information and ideas generally. In other words, the minister could not, without justification, censor and ban television content. The minister does not do this, and nothing about her conduct prohibits people from receiving information or ideas. Now, leaving aside the negative breach of the right, to which I'll come in a moment, this is, in our respectful submission, a deeply impoverished notion of freedom of expression in the broadcasting sphere. Firstly, the licensing of a free-to-air channel in the democratic era was precisely intended as an antidote to the type of state control over the SABC in the apartheid era. The figures suggest that some 13.6 million people are reliant on the analog broadcast of ETV's news and programming. You'll find that in the founding affidavit at paragraph 20. The majority of the population are not able to access television via paid-for means. You'll find that in paragraphs 27 and 168 of the founding affidavit. And ETV is the only meaningful non-state free-to-air broadcaster with national coverage that offers a news service, and its license obliges it to do so, as well as imposing other public service obligations. You will find ETV's license as Annexure PR5 in volume 2 at page 134. So where people are reliant on access to television as a source of news and information, then access to free-to-air television is not an act of benevolence by the state. It is the fulfillment of a duty to respect, protect, promote, and fulfill the rights in the Bill of Rights. And that is precisely the approach adopted by the European Court on Human Rights. Article 10 of the European Convention was indeed the blueprint for section 16 of our Constitution in relation to freedom of expression, embracing the right to receive information and ideas. The approach of the European Court is neatly set out in the decision of Manole versus Moldova. Now, it's referred to in the minister's heads at page 25 in paragraph 96, but let me give you the neutral citation of the case. It's 2009 ECHR 1292 of 17 September 2009. Of course, this court will read the case itself, but let me just read briefly from two paragraphs. In paragraph 99, and this is the immediate answer to our learned friend's argument, the court said, genuine, effective exercise of freedom of expression does not depend merely on the state's duty not to interfere, but may require it to take positive measures of protection through its law and practice. There is then an extensive discussion of that, and under the heading, the state's positive obligation, under Article 10, the court says at paragraph 107, as set out above, a positive obligation arises under Article 10. The state, as the ultimate guarantor of pluralism, must ensure through its law and practice that the public has access through television and radio to impartial and accurate information and a range of opinion and comment reflecting inter alia the diversity of political outlook within the country. Now, apart from this, apart from the minister's positive obligation flowing from section 7.2, the minister, of course, also has a negative obligation not to interfere with the present enjoyment of the right to receive information enjoyed by analog viewers. And any such interference with that existing right would only be constitutionally permissible if justified under section 36. Respectfully, our learned friends all but ignore the argument relating to the negative interference. They provide simply no substantive answer to that argument at all. And of course, this court has in many decisions asserted that rights, that duties may be both positive and negative in their form. Their second defense, respectfully, is equally bad. Our learned friends seek to at least minimize, if not isolate altogether, the minister's decisions from effective constitutional scrutiny by labeling her decision as an executive decision. Now, we don't accept that her decision, certainly in relation to the ASO, was executive in nature at all, and I'll deal with that when I come to the duty to consult. But for present purposes, and by that I mean where there is a prima facie violation of a right in the Bill of Rights, it matters not whether the violation is by executive or administrative conduct. And that is because it is well settled that any conduct, whether executive or administered, cannot limit a right without justification. The clearest statement.
On that point, Mr. Marcus, your 10 minutes protection time is up. Colleagues will now start asking questions.
Can I just give the reference to why I make that submission? The clearest statement in that regard is the Minister of Health versus the Treatment Action Campaign, well known to the court. It's 2002, volume 5 of the South African Law Reports, page 721, where the court said at paragraph 99, where state policy is challenged.
Mr. Marcus, I think the background noise is coming from your side.
Not mine, Justice, but somebody else's.
Is there anyone next to you who has?
No, I'm completely alone.
Okay.
I think it stopped.
Yes.
Yes.
It could be from Advocate Peter Smith's device. I see they're not muted.
Oh, yes.
Thank you, Justices. Paragraph 99 of the Treatment Action Campaign says this: 1292 of 17 September 2009. Of course, this court will read the case itself, but let me just read briefly from two paragraphs.
Justice
In paragraph 99, and this is the immediate answer to our learned friend's argument. Genuine.
There we go.
Thank you. That was a recording.
Yes.
As if it's not bad enough for you to hear me once. Paragraph 99 of the Treatment Action Campaign case is clear. It says, where state policy is challenged as inconsistent with the Constitution, courts have to consider whether in formulating and implementing such policy, the state has given effect to its constitutional obligations. If it should hold in any given case that the state has failed to do so, it is obliged by the Constitution to say so. And of course, that approach has been followed consistently over many, many years now.
Mr. Marcus, if I may try to understand what ETV's submission is regarding the right in section 16. Is the submission that the state has an absolute duty not to impair existing enjoyment of the right or the right to receive information? Or is it that the state has a duty not to unreasonably interfere with existing enjoyment of that right?
Justice Theron, we don't say the duty is absolute. We say that consistent with this court's jurisprudence, it may not interfere with the right of existing access to information unless it can justify it by virtue of the test under Section 36. So we don't say it's absolute.
So then on what basis is the submission being made, or why hasn't the state fulfilled this obligation by allowing registration for an STB as far back as 2015?
I'll come to that, Justice Theron, but let me perhaps try and capture it in a nutshell if I can. We will submit in due course that it's a misstatement to suggest that the registration window has been open since 2015 or 2016. In fact, we will demonstrate when we come to that, that the process had in fact come to a complete standstill, and it was only dramatically and suddenly revived without notice in March of last year. So we will come to that in a moment if I can do so. Can I round off though the submission in relation to their defenses, because as part of the very answer the very question that you have put to me is the question of whether or not reasonable steps have been taken. The third defense is precisely that, Justice Theron. There is the implicit suggestion by the minister and Vodacom that the blame lies with those indigent individuals who have failed to register. You'll see that theme in the minister's heads at paragraphs 88, 93, and 107, and in Vodacom's heads at paragraph 84, where they bluntly say the remedy for all those affected was obvious: to register for an STB. We respectfully submit that that is an unfortunate stance to adopt, because if instead of interrogating why the intake has been so low, the minister and Vodacom would have it that there has been some sort of deliberate and informed decision to accept a broadcasting blackout, which we submit is not the approach that this court should adopt. And Justice Theron,
isn't that the approach that we adopt in the election matters regarding the right to vote and the exercise of the right to vote, where the citizen also has duties and responsibilities in order to exercise that right? Looks like we may have lost Mr. Marcus for a minute.
I'm back.
Yes.
Yes, Justice Theron, I absolutely accept that the answer to the question you put to me will always be fact and context specific. And certainly in the context of the right to vote, this court has recognized very, very stringent duties upon the Independent Electoral Commission to ensure registration. And the adequacy, or perhaps more accurately, the inadequacy of those steps. And my submission to the court is that in this case, a close scrutiny of the steps that were taken will be demonstrated to be precisely inadequate. And can I round off that point, if I may, Justice, by drawing attention to what is a conspicuous absence from the minister's attempt to justify any limitation under Section 16. And on that score, we make 2 points. The first is that to the extent that the minister relies upon a justifiable limitation, the first requirement, of course, is a law of general application. If, as the minister tells us, that there was no law of general application because her decision was a policy decision flowing from the digital migration policy, then the justification exercise fails at the first hurdle. Apart from that, because the minister says there has been no violation of the right, she has advanced no factual justification in her papers at all to justify the limitation. And hence, there is no factual evidence from the minister relating to, for example, consideration of less restrictive means. For example, simply delaying the ASO date to ensure that more eligible people would register, or giving more time to register and a more generous cutoff date for registration. In fact, the
Mr.
reason...
Marcus, isn't ETV's position on that seems slightly confusing? On the one hand, ETV, and please correct me if I've misunderstood what ETV's case is. On the one hand, they say the decision to regarding ASO and switch off constituted implementation of the digital migration regulations and was therefore administrative action. And on the other hand, that the minister's policy decision does not constitute a law of general application. Now, can ETV have it both ways? If the minister is implementing legislation, regulations, then aren't those the law of general application that potentially may permit the limitation? If the minister is not implementing regulations, isn't then that's a strong indication that her decision is not administrative action?
Justice Rerunning, you're absolutely correct. But the confusion, if I could use that word, is not a confusion on ETV's part at all. We are taking the minister on her own say-so. And in that regard, I will point to a confusion. But certainly our learned friends are emphatic that the decision was a policy decision flowing from the 2008 policy. If our learned friends are correct, then there is no law of general application. We are indeed going to contend, Justice Theron, that our learned friends and the minister are both mistaken, and that the minister's implementation of the policy decision was indeed administrative in nature. But I shall address that when I come to the duty to consult. But let me be clear, that is our position. The decision was of an administrative nature, and hence, and importantly for our third topic, it therefore attracted the right to be heard and the duty to consult. But if I could just...
Marcus, I'm interested in your next topic, the duty to consult, and the alleged promises made by government. I'm not sure whether it's an appropriate time to deal with that now.
I'd just like to round off this topic in 30 seconds, and then I'll come to it, Justice, if I may.
Thank you. Thanks.
So, just to round off, there is a complete absence of factual evidence in relation to justification. There is no indication of a consideration of less restrictive means. And ultimately, because the limitation inquiry is one which concerns proportionality, we submit that the impact, the outcome, if you wish, in terms of which millions of people will be cut off, is an utterly disproportionate outcome. And I would like to simply draw this court's attention to paragraph 95 of the Teddy Bear Clinic case, with which this court is no doubt familiar.
Is there any duty on ETV to ensure that its viewers are aware of the process, the registration process? And if so, what steps has ETV taken to ensure that its viewers are aware and do register?
I don't suggest, Justice Mhlantla, that ETV is immune from obligations in that regard. To the best of my recollection, there is some evidence on record in that regard. I'll ask one of my juniors to try and find the reference. I don't want to hold up the court wasting time by looking for it.
Yes.
Can I then turn to the second topic, which Justice Mhlantla, you have foreshadowed?
Mr. Marcus, excuse me, with the leave of the Justice Mhlantla, I would think, speaking for myself, that the point of departure would be the relief that you sought to justify all the submissions as well as the remedy that you would seek at the end of the day. Can you, in your submissions, as you answer my sister presiding, also deal with the relief that you sought? It's couched in the form of a declaratory, order, whether it's an interdict, and if it's an interdict, have the requirements for that interdict been met? And you can do it as you said, you will do it in due course. But I would think this is the first port of call if you are to be heard or succeed on other points.
Yes, Justice Matopa, I do accept that. And I will deal with it in a little bit more detail, but can I just give at least a brief answer to the concerns that you've raised? From the perspective of what we submit to be an unjustifiable limitation of the right, that flows from the determination of the ASO and what we submit to be the unreasonable short deadlines for registration. Hence, the primary relief we seek is review relief, for want of a better description, setting aside the ASO date. The second category of relief we seek are in the form of declaratories concerning the minister's duties. I'm about to address that very topic, but let me simply say that in the context of the relief we seek, we submit that declaratory relief concerning those duties is important because the minister denies the very existence of those duties.
But may I ask, may I ask, the relief that you are seeking, is it in the form of an interdict? And if it is in an interdict, has ETV satisfied those requirements or not? And if it is not, you'd say it's not in the form of an interdict, then we can put it aside.
That's the answer to the question. If you have a look at the relief which is sought in this court, which you will find in volume 24, and the notice of motion begins on page 2388, it is cast plainly and simply in the form of declaratory relief, and that respectfully is our answer to the question. Justice Matopa, I will come to that. The last category of relief, of course, is reporting relief. I'll say something about that at the end, if I may. As to the duty.
Mr. Marcus, I know that we keep on interrupting you, but you are seasoned counsel, and I'm sure you're used to this. I just don't want some of the aspects to be left behind, and then I have to take you back. You mentioned that suddenly last year, the minister started on a process on which there was a complete lull. And then all of a sudden, then the process started again. And what bothers me in this matter is once the minister decided, and I know you are not representing the minister, but I want to follow you your argument as you're progressing. Maybe you can clarify for me. Once there was a decision by the minister that there is a 31st October 2021 registration date. Do you know if there was some form of a public awareness campaign or programs that were undertaken to make people know that there is this date and that they had to register, and what the implications are if they do not register? It also touches on what Justice Mhlandla said about your responsibility. But I'm asking on the side now of the minister, are you aware if there was any effort?
Justice Cheeky, I do propose to address that in a moment. What I can say to you is that if you have a look at the minister's press statement, media release of the 5th of October, and I'm going to take you to that in a moment, if I may, you will see that there was no indication of an embarking on some sort of emergency, because it would be an emergency publicity campaign. And when I take you to the detail of what actually happened, you will see that although her plan envisaged publicity, in fact, the kinds of broadcast and distribution of information in certain instances on her own version took place 3 or 4 days before the 31st cutoff point. I will take you to that in a moment, if I may.
Yes, you can do so at a convenient time.
Thank you. Justices, I wanted to just say something
Mr.
about
Marcus, I'm sorry to prevent you going on to the next topic, but I don't want to leave behind some of the things you've already dealt with without some clarity on my part. You've spoken about the positive and negative obligations that you say that the state has. If you put aside for a moment the promises that you rely upon, and you simply focus for a moment on what the content of the positive obligation is in respect of this matter, I'm trying to understand exactly what the scope of that obligation consists of, because standardly, in respect of access to many different kinds of media, we don't usually think of the state as, for example, subsidizing cell phones or cheapening access to newsprint and the like. So I'm trying to understand where the positive obligation begins and ends, because the consequence of what you seem to be suggesting is that absent a specific promise, the state is in any event burdened with these obligations. So what is the positive obligation?
Thank you, Justice.
Rooted, as I understand it, in section 16, because that seems to be where your argument lies.
That's the source of the obligation. Can I just emphasize that, Justice Untalta, you are correct in recognizing in our argument that independently of any promise, we submit there is a positive obligation. We say the source of that obligation lies in section 7.2, as explained in the jurisprudence of the European Court in the Moldova decision to which I've reported. And additionally, in pointing out that, of course, the state is not generally under a duty, for example, to facilitate access to the print media, broadcasting is different. And that's also recognized by the European Court. It's different because one is dealing with the allocation of a scarce resource, spectrum, which lies exclusively within the control of the state. And that scarce spectrum, certainly in the 21st century, is fundamental to facilitating access to broadcasting. And
so would you then extend that equally to cell phone telephony, which arguably, certainly on some of the submissions before us, is likely to become more important than television sets?
I don't want to close the door on that. Justice Untalta, I'm now going from memory, but you might recall that that kind of argument was certainly foreshadowed in the decision of the Zimbabwe Supreme Court in a case called Retrofit. Now, that was concerned with the licensing of cell phones, but as I recall the decision, and I will try and find the reference, it absolutely recognized that the facilitation of access to cell phones was part and parcel of the right to freedom of expression. So
let me then just turn, because time is short for you as well as for us, to the negative obligation. Why does it go beyond, as long as the state provides a medium for the reception of television signals, why does its negative obligation go further? In other words, the state is not censoring, it's not stopping the transmission of signals, it's simply saying we're using a different means, it's technologically required, it has many benefits. Our negative obligations don't go any further than that.
Well, the negative obligations respectfully do, because however one looks at it, there is the imminent risk that come the ASO, there are going to be arguably many millions of people who currently enjoy access to broadcasts who will no longer have that access.
But doesn't that simply mean, isn't that just another way of saying there's a positive obligation to permit them to transfer to the new technology? It's not a separate obligation.
For purposes of our argument, it matters not whether it's a separate obligation or not. I do submit, however, that the jurisprudence of this court recognizes the deprivation of the existing enjoyment of a right as constituting a negative obligation. We see that in many cases like Juma Mujid, Mazibuko on the right of access to water. There's several other decisions which have recognized it in that way, and we would simply adopt that form of classification.
Thank you. Thank you, Justice.
Mr. Marcus, may I ask you about this, the nature of the power, because it seems to me that will inform the threshold for consultations, which you will deal with later, I understand. But it seems to me the anterior question must be answered as far as possible. Is this executive power or is it administrative action? Now, the respondents, in particular, the minister says this is executive action because it was so held by this court in the electronic media network, which you will recall considered the question of the amendment of the digital migration policy. Did electronic media network answer that question decisively as the minister contends? What do you say?
Respectfully not, but Justice Majid, can I also indicate that I understand my learned friend, Mr. Ferreira, will be addressing that in more detail, and he won't. But let me answer your question immediately, and although it's part of my third topic, it doesn't matter, I won't repeat it. We submit unmistakably that the source of the minister's power are the 2012 digital migration regulations. And we say that once that is so, the action is administrative in character. And I indicated in answer to a previous question that there appeared to be some confusion, I think it was to Justice Theron, on the minister's part. In her answering affidavit, and you'll find this in paragraph 73, she says the regulations empower the minister to determine the ASO date. Our learned friends in their heads of argument say that that's not so. And they insist that it's an executive power, and presumably they feel themselves locked in to that fact because the Gazette proclaiming the ASO says that the source of the power is the 2008 digital migration policy.
Can I just stop you there? Sorry, can I just stop you? I saw that in the minister's heads, and that did puzzle me because they do rely on electronic media network, but that case was decided on the basis that the amendment of the policy is executive action, as the SCA found, and the case proceeded on the basis that therefore it is safe to assume, I think the court says so in terms in paragraph 29 of that judgment, that it's safe then to proceed on the basis that PAJA does not apply, but the test is one of legality, of rationality.
Yes. Justice Majid, you of course will appreciate that after the digital migration policy of 2008, the digital migration regulations were promulgated. They were promulgated in 2012. Yes. So it is those regulations which give effect to the policy.
Yes.
And if one has regard to the definition of dual illumination period in the regulations, you'll find that, Justice, in volume 3, page 288. The dual illumination period is the period commencing on the date of digital terrestrial television switch on, as determined and published by the minister, and ending on the date or dates of analog television switch off, as determined and published by the minister. And then if you look at regulation 3, it says that the date of commencement of the dual illumination period, as well as the date of final switch off of the analog signal, will be published by the minister in the Gazette. So the scheme of the regulations is absolutely clear. It requires first of all, they give effect to the digital migration policy. And secondly, they vest in the minister the power to determine the cut-off date. And that's why we say, Justice Majid, just to round off this point, that this doesn't take it out of the realm of administrative action in the sense described by this court in the Edu College case, which we referred to in our heads at paragraph 80.3. In fact, the scheme adopted here precisely fits the Edu College decision. The executive took the broad policy decision that there should be a migration from analog to digital. It is the minister who then implements that decision in terms of her powers under the digital migration regulations. That is administrative action, and hence we submit it attracts the right to be heard. But
can I just ask a follow-up question to that?
Of course.
It is also suggested that what has happened here with in this instance is part of the ancillary powers to the minister's executive powers of making policy. In other words, it's a Minister of Defense versus Motau type of scenario. That is the second leg, as I understand it, to the minister's case, that this is executive action, not administrative action. What do you say about that?
Twofold response, Justice Majid. The first is, and again, I don't want to trespass on my learned friend Mr. Ferreira's argument, is that for purposes of the duty to consult, it matters not whether the action is executive or administrative. My learned friend Mr. Ferreira will address why, even if it is executive, rationality requires that there be consultation on the critical issues. We submit that it is not executive, that it is administrative in character, and this is part and parcel of really a very typical feature of administration in the modern state. The high-level policy decisions are taken. They are normally given expression in statutory form, and there are thereafter administrative mechanisms for their implementation. That is your quintessential administrative power and action.
Thank you.
Justice Majid, if I may follow up, Mr. Marcus, doesn't the regulations only say that the minister will determine the switch-off date as per the definition of dual elimination period that you have just read to us?
Yes.
So this doesn't confer on the minister the power to determine the date. It presupposes that the minister already has that power. And if you look at Regulation 3.1, that also does not confer power on the minister. It says, and I quote, the date for the commencement of the dual elimination period, as well as the date for the final switch off of the analog signal, will be published by the minister in the Gazette. Yes.
Sorry, Justice. If you look at the definition
let me put my question, Mr. Marcus.
Certainly.
Doesn't it therefore follow that ETV may be incorrect that the minister was implementing the regulations? And wasn't she instead exercising original constitutional powers and policy-making powers under the Act?
We submit not. First of all, one has to have regard to the definition of dual illumination period, which envisages a determination by the minister. We submit that that determination takes place under Regulation 3. And secondly, we submit that if one has regard to the question of where the policy...
I'm really sorry, Mr. Marcus, but Regulation 3 says she determines the date.
Yes.
Does it confer the power? Does that confer the power on her? That is my concern.
Yes. Justice Theron, in our submission, it does. If we are mistaken, and if this is somehow an original constitutional power, the argument will be certainly for purposes of consultation and the right to be heard, that that obligation persists, regardless of the classification of the power. And can I just briefly say why? The decisions, however classified, entail as their ultimate outcome whether or not potentially millions of people will continue to enjoy the right of access to television broadcasts. In other words, they are the kinds of decisions, whether executive or administrative, which directly impact upon people's rights. And once that is the case, we submit it triggers a duty of consultation and a right to be heard. So we are not fazed, Justice Theron, by whether the correct label is executive or administrative. We do submit, however, that it is administrative. If we are correct in that, on that score, then the route to the duty of consultation and the right to be heard is more direct. We, of course, accept that proposition.
But isn't it important to establish what kind of power is being exercised, Mr. Marcus? Because then it also determines the scope of powers of review of this court and under what circumstances this court can interfere with that decision.
I absolutely accept that, Justice Theron. So let me nail my colours to the mast. We submit that the decisions are administrative in nature. I have explained why we submit that that is so. We, of course, accept that underlying those decisions at a macro level, there was a policy decision. That policy decision was the decision that the country as a whole needs to migrate from analog to digital. The way in which that process is to unfold is regulated by the digital migration regulations, and that includes the source of the power we submit to determine the ASO. That's our argument. As I say, my learned friend, Mr. Ferreira, will cover the bases and in the event that we are wrong in that regard. Can I then go to the source of the duties? And I'll try and truncate this because some of the ground has already been covered. But can I simply start by saying that with which this court is familiar, is that going back to the 2008 digital migration policy, the state has recognized that there has been a need to ensure access to broadcasts by as many people as possible, and particularly to take active measures to ensure that those who can't afford it are given access to digital broadcasting. That is reflected in the various iterations of the digital migration policy. It is confirmed in the broadcasting, the fact sheet, which you will find as Annexure PR 29 in Volume 3. And it is again confirmed in the minister's statement dated the 5th of October, but apparently issued only the next day. That is Annexure PR 17, which you'll find in Volume 2 at pages 213 to 218. So those are the official statements. There was also a statement by the Post Office, and I wonder if I could just draw attention to that. It came on the 21st of October. That is roughly 9 days before the cutoff. It's PRA1, and it's in Volume 20 at page 2134, which again repeats the promise that qualifying households do not have to pay anything for the set-top box. But importantly, at the foot of that announcement on page 2134, it tells you something about just the extent to which the process had stalled. It says the SA Post Office is aware that some families registered for a set-top box at the beginning of the campaign, but the installation has not been done yet. And I'm going to elaborate on how the process basically came to a standstill. But there, the Post Office is telling you that some of those who registered at the very outset in 2016 still don't have access to, still don't have actual physical set-top boxes. And of course, those undertakings were repeated on oath in these proceedings. And I'll just give you the references. It's in the minister's answering affidavit at paragraphs 199, 375, and 666. Now, in answer to questions that have been posed, the question arises, why did the state make these promises at all? And we submit that these promises were made not simply as an act of benevolence or kindness. These were pursuant to statutory obligations. And we submit that the source of those statutory obligations is fourfold. The first is section 7.2, and I've addressed that already in the context of freedom of expression, and the European Court approach that it imposes a positive obligation. The second source of that obligation, which appears from the digital migration policy as amended in 2012, is section 88 of the Electronic Communications Act, which imperatively requires money from the Access Fund to be utilized for the payment of subsidies for the assistance of needy persons towards the cost of the provision to or use by them of broadcasting. And that will be read with section 87.4, which makes it clear that the fund operates subject to the control of the minister. The third source of that obligation is the Broadcasting Act of 1999. And the fourth source of the obligation we submit is section 195 of the Constitution. So, Justice Unterhalter, with respect, you are correct when you say our case does not hinge simply on the making of a promise. Our case hinges equally on the breach of what we submit are a range of duties. So we submit that this case does engage the KZN principle. Our learned friends seek to limit the scope of that principle in a number of ways. They, in the first instance, suggest that the KZN principle was confined to the facts of that case. Respectfully, they are mistaken in that regard, because that is the very argument which was considered and rejected by this court in the subsequent case of Pretorius, in which it is recorded in paragraph 26 of Pretorius that the applicants rely on this as establishing a general principle not restricted to the facts of KZN, and this court agreed with that proposition. So,
Mr. Marcus, the promise that you are referring to,
yes,
should we have any regard to the question, the requirement of those that qualify to register?
Yes, yes, absolutely, Justice McClellan. Can I come to that in 1 minute?
Okay.
Well, in fact, let me come to it immediately. It's the second. It's the way in which our learned friends seek to limit the ambit of the promise, and they do so in a number of ways. So let me deal with that immediately. First of all, they say that the promise never extended to each and every person requiring a set-top box. In other words, they say it would be absurd, and incidentally, we agree, to suggest that the ASO could not occur unless and until every last qualifying individual had a set-top box installed. Now, that is not our case. And in the High Court, we made that clear by virtue of the draft order, which we handed up. And it is equally clear by reference to paragraph 2 of the order that we seek in this case. What we submit is that the obligation extends not to each and every last individual, but simply to ensuring that the minister take reasonable and justifiable steps to provide indigent qualifying households with access to STBs. So we accept the standard of reasonableness, which does not, we accept, extend to every last individual. What we do say, however, is that it cannot leave out of account potentially many millions. So that's the one way in which our learned friends seek to limit the scope of the promise. The second is the one which our learned friends also suggest, is that it is limited only to those who registered. we have a number of answers to that. The first is assuming it to be correct, and that the promise made was not in the words that the minister herself uses, that no one will be left behind. But let's assume that the promise extended only to those who registered. Our argument is that the minister cannot frustrate her own promise by imposing unreasonable conditions, which would render the fulfillment of that promise impossible. And if one has regard to what in fact occurred, the facts are set out. And if I could give you the reference in the replying affidavit in volume 20 at paragraph 36, which cross-refers to the minister's press release. I said I would come back to this, and here it is. So what emerges from this is that although the 5th of October was the date of the minister's announcement, the SABC broadcasts only began to run approximately a week later on the 11th of October. Many of the announcements scrolling on television only began as late as the 18th of October. Banner messages advising of the need to register were distributed or published on the 27th and 29th of October, with literally days to go. And the consequences we submit are unsurprising. There was a minimal uptake in the reopening period in that 3 weeks of October. And
sorry, Mr. Marcus, you said volume 20, paragraph 36. What page is that? Sorry to interrupt. What page is that? You just gave us a paragraph number.
I beg your pardon. It's at pages 2089 to 2090. And Justice Majid, you will see those paragraphs cross-reference everything I've just said to the minister's press release of the 5th of October. I apologize for not giving the reference. The last point, Justice Ntlantla and Justice Chiki, is the argument of our learned friends to say that this registration period has been open for 6 years, and we are constrained to submit that that is a cynical answer, and we say so for these reasons. It's because it's not in dispute that the digital migration process had stalled for many years. So while notionally the registration window was opened in 2015 or 2016, there was no indication that the government, in fact, intended to proceed with migration anytime soon. And the best indication of this is the fact that despite notional registration being open since 2015, the government stopped installing STBs in January 2019 and only appears to have restarted in October 2021, and in the process leaving hundreds of thousands of registered indigent households without STBs for years, even though they had registered. You will see that in the minister's answering affidavit at paragraphs 265 to 267, in volume 10 at page 1040 to 1041. So between January 2019 and October 2021, registration was evidently pointless. And at no point prior to the announcement of the cutoff date, and with at best for the minister 3 weeks notice, had government ever suggested a cutoff date would be imposed, or that it would again proceed with installing STB boxes in a process which had come to a halt. So,
Mr. Marcus?
Sorry, Mr. Marcus.
Mr. Marcus,
yes.
Can you also address what the minister, and to a certain extent Vodacom, says as well, that in any event, even though there's a cutoff date, the minister is not strict about the cutoff date, in that people who did not register before the cutoff date were still allowed to register and will still get set-top boxes. But it will be sort of first come, first serve basis.
Correct.
And therefore, does that not deal with whatever problems were there in communicating the cutoff date to the public?
Justice Cheeky, we don't suggest that come the 31st of October, the opportunity to register is closed forever. We don't suggest that. We accept that part of the minister's statement of the 5th of October envisages late registration, but it comes at a cost. And the minister's press release makes clear that those who register after 31 October will encounter a delay of 3 to 6 months. Can I just pause there and just ask this court to put themselves in the position of those who might be hit by that delay and to consider the impact upon them of a potential news blackout of up to 6 months. And my learned friend, Mr. Ferreira, will deal with the actual numbers involved. And it will demonstrate, we submit, that the impact is going to actually touch potentially millions of people. So whilst we accept that the door to registration is not closed, the more fundamental question we respectfully submit is why the minister took this decision so precipitously, and why, having regard to the feeble uptake, the period for registration wasn't extended, and why concomitantly the date for the ASO wasn't extended. That is your textbook example we would submit of less restrictive means. So we would submit—
Mr. Marcus, just apropos that, even if you were correct historically, time has now moved on.
Yes.
So notionally, at any rate, you can tell us what you say a reasonable time would have been, but let's say it would have been 2 months or even 3 months. Well, that time has now come and gone. So at some point, one has to say that those who are potential beneficiaries also have obligations. And at a certain point, we can no longer wait for them to exercise the potential to benefit from this program. So if you then say, well, it's 2 months, let us say, after October, then there is a cutoff for beneficiaries. And then the knock-on question is, well, how much more time is needed to then provide the set-top boxes?
Well, Justice—
In other words, just to be plain, even if everything about your case is correct about what happened in October, time has cured that breach.
Well, Justice Untalto, we've got a number of responses to that. The first is we await to hear from the minister what the current updated figures are. You will be aware that in the High Court, despite a process of repeated letters and requests, despite a specific request to the minister to give accurate figures.
But why does it matter, Mr. Marcus? I'm sorry to interrupt, but why does it matter? There's a certain time after which one has to say that those who don't take advantage of registration, we can no longer constitutionally count their interests any longer. Well, perhaps you don't accept that proposition, but it seems generally accepted as reasonable that if you're given an opportunity, a reasonable opportunity, and you don't take it, at a certain point, your interests can't count any longer. Do you accept that proposition?
I do accept the proposition, and I don't suggest that these rights or these expectations must exist in perpetuity. I accept the proposition. What I do say, Justice Unterhalter, is that as things now stand, and to the best of our ability, on the facts which are exclusively within the knowledge of the minister and, dare I say, Centec, this court can confidently accept that there are going to be millions of people who are going to be subject to a blackout. Now, precisely where one draws the line may well be a difficult exercise, and I accept that. But on the facts of this case, the minister continues to be on the wrong side of that line. That is our submission.
Well, just to be clear, exactly why is that so? I mean, take whatever period you think is reasonable. But if there was, say, 2 months after October, that would take us to the end of last year. And then it's a question of saying, well, what's a reasonable time within which anyone who registered over that period should be provided with a box? And thereafter, the switchover must take place. This is on accepting everything about your case, just for a moment. And aren't we already virtually there?
Before you respond, Mr. Marcus, your allocated time is up. How much more time do you need?
I've dealt, I think, with the duty to consult sufficiently. So I would probably need 5 or so minutes, Justice. Thank you.
You may proceed.
Justice Unterhalter, there's an anterior question which we submit is necessary to be addressed before simply considering whether the time is sufficient. And that is whether there has been an adequate public education period, and so that the people who are most vitally affected are in a position to take an informed decision regarding their rights. Now, we submit that really doesn't lie in the minister's mouth to say, well, this has all been happening since 2015. The Post Office tells us that even those who registered at the outset still don't have sufficient set-top boxes. My learned friend, Mr. Ferreira, will address the court on the rate of the installation of these set-top boxes and whether it comes near satisfying the requirements to ensure that people are not unfairly or unjustifiably deprived of their existing access to digital broadcast, to broadcasting in the present case. But the real problem, Justice Unterhalter, is that this has been a botched process. Justice Matopo, yes.
Please proceed, Mr. Marcus.
I'm sorry, I didn't hear the question.
No, sorry, I'm muted.
Was there no question? I beg your
No,
pardon.
there is. Sorry, I'm muted. I'm just wondering.
Yes.
And please help me here. The minister seems to have done everything possible to ensure that South Africans are aware about digital migration. And if you look at the number of the people that have responded vis-a-vis the numbers that we've put as not having responded, the numbers are much bigger. And then what do we make of it? Because we cannot, in reality, have everyone and all of us responding to the call. This after us from work integral will not help. We can't wait for that after us. At some point, we have to do something.
Justice Matopo, can I respectfully take issue with the underlying premise of your question to me? And that is that the minister has done everything possible. Of the minister's own figures, the ones she gave in her notice of the 5th of October, there were some 2.3 million households, I think it was, who had not registered, which on the Stats SA figures represents 8 million individuals. Now, I respectfully submit, Justice Matopo, that this court will be hard-pressed to say that in circumstances where the numbers are so massive that it can be attributed to the indifference of those who qualify for set-top boxes. Instead, this court, I submit, will draw the more reasonable inference, and that is that the affected individuals did not take a deliberate decision not to register, but rather there is an intrinsic problem with the mechanism adopted by the state and successive ministers. I appreciate that the current minister is a new minister, and she has inherited a great deal of what has gone before. But we certainly take issue with the underlying proposition that everything possible has been done. One simply looks at it at the level of outcome to appreciate that that is not the case. Justice
Colapan had a question, but I would like Mr. Marcus perhaps to use the 5 minutes to round up on your topics before we ask any questions.
Justices, I have addressed the duty to consult, which we say flows from the administrative nature of the decision, but in any event makes no difference whether it is administrative or executive in nature. I have already partly addressed the question of remedy in response to Justice Matopo's questions. I suppose there is only one aspect of remedy which I should say something about, and that is the relief by way of reporting. We submit that in circumstances where one is dealing with a case in which very, very large numbers of people are affected, much like occurred, for example, in the social grants case, that this is an appropriate case for a reporting duty. And it is particularly appropriate in circumstances where, if our argument is accepted, it is an instance in which the minister has first of all disavowed any duty to consult at all. She says she was under a no duty whatsoever. We say it is also especially important in circumstances where the public has a vital interest in the transparency and openness of what the process entails. And we submit that ultimately that reporting obligation will facilitate the process rather than obstructing it. May I point out that I happen to have been in 2 of the cases in which reporting duties were imposed, and that was All Pay and August versus the Electoral Commission. In neither of those cases was the reporting obligation requested by the applicants. They were obligations imposed by the court of its own accord in recognition of the importance that that reporting function serves. Thank you, Justice Mhlantla.
Yes. Any Justice Colapan? I think you had a question.
Thank you, Justice Mhlantla. Mr. Marcus, in response to an earlier question, you indicated that the relief you sought was purely declaratory in nature.
Yes.
It seems to me that even though, and I'm looking at the declaration that the digital migration process may not be completed until the minister has complied with her constitutional obligations. That's one of the heads of relief you seek, correct?
Yes.
Is that not an interdict, even though it's couched as a declaration? Because it really says that the minister may not do this. The minister is prevented from doing it until she's taken certain steps.
Justice Colapan, there is a way of, in a sense, conceiving every declaration of rights as ultimately having the effect of a form of the effect of being interdictory in nature. We don't have a difficulty in a reformulation of that prayer, which would simply declare that that before declaring the ASO, the minister is required to do X, Y, and Z, or that the minister's obligations, it is declared that the minister's obligations are X, Y, and Z. We are not wedded to the form of the prayer, and we have no difficulty in a reformulation. And on that score, as has been said often enough by this court is at large when it comes to remedy. This court is not bound by the way we have formulated it, or indeed by the way we have argued it. But let me get to the nub of your question. Our concern is a very simple one, and we appreciate that there are different ways of achieving the outcome we succeed, well, the outcome that we wish in order to succeed. We simply want it made clear what the minister's obligations are in order to achieve a lawful digital migration process. We don't mind in what form those obligations are couched.
And you would accept that the outcome of that may well be that some may be left behind, not deliberately so, but,
Yes.
but that may well be a consequence.
Absolutely. Our standpoint, sorry, Justice, our standpoint is clear. It is not our case that the ASO can only occur unless once each and every qualifying individual has registered. What we contend for is a reasonableness standard.
On the consultation process, the minister says, that is now insofar as ETV is concerned, the minister says, in fact, there was consultation with ETV over a number of months from February 2021, and ETV was part of a steering committee, made certain recommendations or submissions. So what is your response to that?
Our response is twofold, Justice Mhlantla. The standpoint of the minister is that she was under no obligation to consult. So going into a process with a mindset that I don't have to be here at all is scarcely conducive to the kind of open mind that is required for a genuine consultation process. The second point we make is this, is that if you have regard, Justice, to the process that in fact ensued and which is reflected in the 6 letters that were written, and I'll give you the reference in a moment, there was an ongoing attempt by ETV to get clarity from the minister concerning the process regarding registration and the measures that would be put in place and the determination of the ASO. Most of those letters were simply unanswered. When it came to filing the answering affidavit in which the minister had undertaken to provide that information, not even then was it provided. You will find the references to the 6 letters in our heads of argument at paragraph 25.1 and particularly footnote 32, and again at page 35, paragraph 81 of our heads. And the last point, Justice Mhlantla, is that our learned friends for Vodacom try to smear ETV by suggesting that they only have a commercial interest at stake, as if that were some unpardonable sin and somehow strips ETV of its rights. That has never been the approach of this court, and it is wrong in principle. But importantly, ETV's viewers have a vital interest in this case. And in terms of its license conditions, it has obligations in relation to news services and all sorts of public sector broadcasting and in different languages. And they too have a right to be heard. All that was required, Justice Mhlantla, was the most simple notice and comment procedure. That would have done the trick, but not even that was done.
Thank you. One last point from my side. The sale of the public auction, sale of the spectrum, does it have any bearing on the case?
Thank you, Justice Mhlantla. It was at one point perhaps the most vital question, because when the auction was originally envisaged and Telkom and ETV went to court on that, the standpoint of ICASA was that the moment the spectrum was allocated to the successful bidder, that successful bidder would have immediate use of the spectrum. In other words, even though the spectrum was occupied at the time by ETV and others, that wouldn't matter. They would be as it were, instantly migrated off the spectrum, and that spectrum would be allocated to the cell phone operators. That was why Justice Bakwa inter alia granted the interdict. The current spectrum process operates on precisely the opposite footing. It says the auction can go ahead, and it has gone ahead, but beneficial use by the successful bidders will only occur once the digital migration process is complete. So there are now safeguards in that respect.
Thank you.
Mr. Marcus, just two small points related to your consultation issue. The first one relates to the number of registered or unregistered households that will be impacted negatively, as you suggest. The minister's argument is that this is an unknown variable and it can be allowed to stall the process. That's the one question. I want to know what your response is to that. But the other one, which is related, is the minister's argument is that SABC and Mnet have switched off their analog transmitters. They are now on the digital platform, but ETV has not. And you've just told us to the question now from Justice Mhlanhla that ETV has obligations to its viewers. What do we make of that fact? Thank you.
Thank you, Justice Mlambo. On the first question, that the numbers of affected households is an unknown, and therefore the process cannot stall on that basis. We respectfully submit that that is a remarkable argument coming as it does from the minister. The minister is in charge of this process. So is Centec in charge of implementing the process. My learned friend, Mr. Ferreira, will address this in more detail, but in a nutshell, we would submit that that process, by definition, must be irrational if the very parties responsible for its implementation have not investigated and therefore do not know the exact or at least a relatively accurate number of those who are affected. So we would submit that that counts massively against the minister in this particular case. In relation to the limited switch off that occurs, what we do know, Justice Mlambo, is that the numbers in the scheme of things, as we understand it, is relatively insignificant. So one can't exacerbate one can't exacerbate the situation by simply going to full switch off in circumstances where, on what the minister tells us, we can't go do better than that. The minister tells us that, I think it's in her statement of the 5th of October, that there were 2.3 million households which had not registered. The coefficient, according to the Department of Statistics, is 3.3 persons per household. That translates into 8 million people. It scarcely lies in the minister's mouth to come to this court and say, those 8 million don't really matter.
Justice Mhlanhla, if I may, I have a few questions for Mr. Marcus. The one is following up. Sorry, Justice Mlambo, do you have a follow-up question?
Yeah, that was just a small follow-up to say the point being made by the minister on the switch off of the analog transmitters is that only ETV remains fully on that platform, and this will pose a problem when the migration has to happen. That's why I think the minister is making this point.
Yes, the minister is perfectly alive. The fact that it is only ETV that is still on this platform may well be correct. I accept that it is correct. The real question, however, though, is, well, what are the consequences of ETV remaining on that platform until the date of the switch off? If the switch off were to occur, as the minister anticipates it will imminently be, The consequence of that will be that potentially many millions will be blacked out. Now, that's the fight that we are having. We are having it, of course, qua ETV. My learned friend, Mr. Ferreira, is having the same fight in the public interest, but it amounts to the same thing. That the absolute core question which this court has to confront is the impact of these decisions. We say that that is an impact which impacts upon fundamental rights, and we say it is an impact which is about to take place without adequate consultation. That, we submit, is simply not constitutionally compliant. Hence, we come to this court for an appropriate remedy.
Mr. Marcus, as a direct follow-up on that, I want you to refer you to the minister's evidence in the High Court. We don't need to go there, but it is in volume 10, page 1047, paragraph 288. And what the minister says is that switch off has been implemented in the Free State and partially in the Northern Cape and the Northwest. Now, what evidence has ETV put up which would allow us to reject this evidence of the minister in terms of Plaskon Evans? And if we accept the minister's evidence, doesn't it show that the adverse effects which ETV is talking about is not a reality?
Justice Theron, in answer to your first question, I will have to check whether there is a response in reply. I don't know offhand. I'll get my learned friend, Mr. Duplessis, to deal with that in reply. But secondly, as to adverse effects, we need not speculate because we know what the potential adverse effects are when this switch off takes place. On that score, the evidence is not in dispute. Indeed, all the minister's own pronouncements make clear is that when the switch off takes place, absent either a smart television or a set-top box, you're blacked out. So we know what those consequences are.
Has there in fact been that evidence of places where there has been switch off, like in the Free State and partially in the Northern Cape and Northwest?
In relation to what has occurred since that switch off?
Yes.
Justice Theron, I will check that. I don't want to give an inaccurate answer.
Now, the minister has disclosed a consultation process that was followed. Well, let me be specific. Consultation around the proposed date of the ASO switch off. She has also said that ETV was involved in those consultations, that ETV made submissions similar to those submissions that it has made in the courts and that is now before us. What new information or what more can be gained from a further process of consultation?
Justice Theron, first of all, ETV is not the only interested and affected party, in respect of which there is a duty to consult. Certainly in relation to the broader public, the kind of clients my learned friend Mr. Ferreira represents, there's been no consultation at all. So there is obvious merit in that. The second point is, as I've already submitted, the most crucial questions in any consultation process would be these. The first would be consultation around registration and the cutoff for registration. And secondly, consultation around the ASO. The reason why those would be the most critical issues in respect of which consultation would be required, because of the consequences in the first instance of registration and in the second instance of the switch off. What we can say with certainty is that at no stage did the minister put out for general consultation any issue around registration and its cutoffs, and secondly, around the date for the ASO. So we have the consequence of that is that we are in the situation in which we find ourselves today. And that is that the absence of consultation threatens the rights of many millions. And can I make this point, Justice Theron, which is often overlooked, but which this court has made clear on many occasions, and Joseph and the Johannesburg City Council is a good example, is that the duty to consult has got a twofold purpose. It not only respects the dignity of those who are potentially implicated by a decision about to be made and gives them an opportunity to influence that decision, undoubtedly critical as that is. But the second justification for consultation, particularly in a case like this, is especially important. And that is that it is conducive to more accurate decision making. In other words, it renders the ultimate decision a rational one, because the decision maker is placed in possession of the critical facts. It links back with what I just dealt with, and the suggestion from the minister that the numbers aren't accurately known. Well, had the minister consulted with people like MMA and SOS, she would have been in a better position to answer that very question, which was integral to a rational ultimate decision.
Now, Mr. Marcus, on that and the number of people, the minister's response is that the STB registration process was her means of obtaining that information. Why is she wrong when she says that? Well, when she says she did what she could reasonably do. And isn't ETV in effect saying that the minister should have used alternative and better means of obtaining information, but doesn't that go beyond the realms of a rationality challenge?
I'm not doing the rationality challenge, but let me answer it in this way. There are undoubtedly a range of ways in which the minister could have been better informed. And consultation, Justice Theron, would have been the best way to do it. And particularly consultation with those who had particular expertise in the area. And that at a minimum, I don't suggest there aren't others, but at a minimum, ETV would have been one of them, because they are the biggest free-to-air broadcaster. They know something about their own audience. But it would have been specialist NGOs like MMA and SOS. And that is the value of consultation. And respectfully, there is no substitute for that. And it doesn't behove the minister to say, oh, well, the process of registration was what was going to give me a relatively accurate figure. If the registration process was as flawed as we submit it was, and a process which had come to an effective standstill, then it simply doesn't lie in the minister's mouth to ask this court to accept that her process was either reasonable, as we say it had to be, or rational, as my learned friend, Mr. Ferreira, will tell the court in a moment.
My last question relates to the relief that ETV seeks. ETV appears to suggest that about 16 months is needed to roll out ASO. Wouldn't an appropriate order perhaps be one that extends the date of ASO, or ask the parties to make submissions, such as with this court as oversight or the High Court as oversight, as to how much further time is needed for the rollout?
Justice Theron, we would certainly accept that as one of the range of permissible remedial options open to this court, and I don't want to be heard to stand in the way of that. The reporting obligation might serve to achieve precisely that, but in relation to what I think, Justice, you might be aiming at, and that is a sort of two-stage process, much like we adopted in All Pay, I'm not going to be heard to stand in the way of that.
Thank you, Mr. Marcus. Thank you, Justice Mhlantla.
Thank you, Mr. Marcus.
Justice Mhlantla, I'm terribly sorry. Could I just ask Mr. Marcus one final question? Mr. Marcus, you do rely on the KZN principle.
Yes.
One of the main arguments that's raised against you is that the promises are revocable, and so it doesn't really apply until the promise vests, as it were, and the promise hasn't vested. So very briefly, because time is now very short, if you could just indicate how you answer that proposition. And then secondly, if you're not relying on promises, you have indicated the statutes that you rely upon. You don't need to repeat anything about the Constitution, but you've referenced section 88 and 87.4 of the ECA and in general terms, the Broadcasting Act. But what specific breach of statutory duty are you actually alleging? Statutory as opposed to constitutional duty? Just very briefly, if you would.
Let me deal with the latter first, Justice Untalter. The specific breach, and I'm going to use the colloquial phrase, is not to leave anybody behind. That's what section 88 specifically addresses. It says indigent people must be allocated or must be given the means with which to allocate broadcasting services. The Broadcasting Act is similar. It imposes a duty on the state to create what it calls a broadcasting system, which ensures access to television broadcasts. And section 95, the section 195 obligations, with which you'll be familiar, requires inter alia that people's needs must be attended to, etc. There are a range of those duties. We say that in circumstances where potentially millions are going to be left behind is a breach of those duties. In relation to the potential revocability of the promise, we don't understand the minister ever to say in explicit terms that she is reneging on the promise. On the contrary, her case is she is fulfilling the promise. But postulate that I'm mistaken in that regard. There would have to be a justifiable basis for that promise to be revoked. And we would go further and submit that it would have to be done in accordance with a process which was fair in circumstances where there has been prejudicial reliance.
Yes, thank you. Thank you, Justice Mhlantla.
Thank you, Mr. Marcus. I think we've gone way beyond our range time, but we ask questions, so we are not blaming you.
No, I mean, thank you, Justices. Thank you.
Thank you. Thank you. Justice Theron, do you have an IT issue to raise before we attend?
Yes, thank you, Justice Mhlantla. It's perhaps for the attention of Mr. Matteau and his junior. I see that Mr. Smith has been trying to connect on a device, and that he might no longer be on that device. He might be on another device, but the device that is showing that he's trying to connect, we occasionally getting background noise from that device. So just for the team to look at that and to perhaps switch off the one device that is indicating on our side that Mr. Peter Smith is trying to connect, because that's where background noise is coming from, and I'm unable to mute him from my side.
Thank you.
Thank you, Justice Mhlantla.
Thank you. We'll take a 15-minute adjournment for tea, and we'll resume at, what time is it? 11:53, according to my clock. No, it can't be 53. 12 o'clock.
It's
what time is it?
Yes, it'll be, I think, just 2 or 3 minutes past 12 o'clock, Justice Mhlantla.
12:03.
Thank you.
Thank you.
Court will adjourn until 12:03. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 12:03. Should you exit, you may use the same link to rejoin the hearing.
Ms. Jones, are we all
Justices?
in? Yes.
Yes. Justice of the Constitutional Court, all counsel are online.
Thank you. Thank you, Ms. Jones. Mr. Ferreira?
Thank you, Justices. As Mr. Marcus indicated, I propose to address the following points. Firstly, to go into a bit more detail about the facts about the impact of the decision to determine analog switch-off and on the date that the minister decided. Secondly, to deal with the unlawfulness of that decision, which underpins the review relief at the level of rationality review, and also if it turns out that the decision was administrative in terms of the law of administrative action. Thirdly, briefly to say in relation to those hundreds of thousands of households that have already registered, when and for how long can they be expected to be plunged into television darkness as a result of the precipitous rush towards analog switch-off in relation to achieved rates of installation? And finally, some brief submissions on the question of remedy. Justices, in relation to the first point, the facts about the impact of the decision, this is a matter which concerns the validity of the minister's decision to determine the date of analog switch-off. That is the decision which was brought under review by both ETV and my clients. And we submit that if the selection of a particular date, be it end of March 2022 or end of June 2022, and critically, the process followed by the state in preparing for migration by that date is a process and a decision that will result in millions of indigent South Africans losing their access to free-to-air television, then it plainly constitutes a retrogressive measure in relation to their expression rights. And so the facts on this issue is something which it is critical to understand. Before I get into the facts, I should submit that it is also important, not as our learned friends for Vodacom and the minister do in their heads of argument, and as some of the questions from Justice Unterhalter to Mr. Marcus seem to accept, it's important not to conflate the permissibility of the destination with the permissibility of the means chosen by the state to get us to that destination. Everybody accepts, including ETV and my clients, that the end goal by which that this country needs to end up in is one where one has both widespread access to free-to-air television through digital transmissions on the one hand, and on the other hand, the improved telecommunications that will result from freeing up scarce spectrum. We all accept that that's the destination. That is not in dispute. Neither ETV nor my clients challenge the policy decision to turn off analog and through doing so to free up the scarce spectrum and bring us to that future world. What is in dispute is the route that may permissibly be taken to reach that destination. We submit that the route that the minister has adopted to implement that policy decision is one which fails to give effect to the expression rights of millions because of the rushed and shambolic process which was adopted, because of the last minute implementation of a 3-week deadline for registration, and because of a failure to consult and a failure to consider the impact. And so it's not a choice, as Vodacom would have you find, between a policy decision of different means to realize freedom of expression. On the one hand, telecommunications through one's cell phone, and on the other hand, television broadcasts. The policy decision is we must have both. The question is, how may we get to that point? Justices, on the common cause facts in relation to impact, the overview of our submissions are the following. It's established that there are approximately 2.25 million households who are eligible for government assistance to obtain set-top boxes, but who have not yet registered for that assistance. It is common cause that the state has no idea how many other South Africans still require assistance to obtain set-top boxes, because it has made no effort to find out other than the defective registration process. And what we also know, and what the Minister glosses over in her submissions with respect, is that at present, on the uncontested facts of an independent expert from the Broadcast Research Council, 36% of the population as a whole, or 5.7 million television households, is currently reliant on analog signal for its viewing of free-to-air television. And so the speculation that we have in the papers that maybe these people have self-migrated is not sustainable on the undisputed facts. What the Minister says is that she conducted a registration process, and that registration process was the method for determining how many people put up their hands for assistance. Our submission in response to that will be that that process was manifestly not fit for that constitutional purpose, because it was bungled, it was rushed, very little was done until after the 5 October press statement, which announced the 3-week deadline. And as a result, that registration process is not a reliable proxy for the need. It is not a reasonable opportunity which was provided to the indigent to put up their hands. And finally, Justices, we will explain to the court why on these facts, even in relation to those who have managed to register, on the historically achieved installation rates, the promise of 3 to 6 months of a TV blackout is completely unrealistic. And what one can see on what has been achieved to date is that those people who have registered are looking at a period of anything up to 2 years before their set-top boxes will be installed. And so we say in those circumstances, it could never have been lawful for the Minister to determine the date of analog switch-off. The first question is, how many South Africans need assistance to obtain a set-top box? We know that the Minister estimates it's 3.75 million households. She says that in her answering affidavit, volume 10, page 1039 at paragraph 255. The court need not go there. In reply, my clients say it's likely more in the light of COVID and the damage done to the South African economy, but let's assume in favor of the Minister, it's 3.75 million households. That's 12.3 million individuals. How many of those have actually managed to register for a set-top box? From 2015 to 31 October 2021, it was some 1.228,879 million. So about 1.2 million that one finds in the Minister's answering affidavit at page 1040, paragraph 259. That was up until the 31 October hard deadline. Between 31 October 2021 and 10 March 2022, an additional 260,868 households managed to register. That one finds in the Minister's supplementary answering affidavit in volume 21 at page 2242, paragraph 17. And let me just pause to say that it's common cause that all 260,000 of these individuals will lose access to free-to-air television for at least 3 to 6 months, and we'll explain why. In fact, it will be longer. And so the total of registered television households is 1,489,747 households. That leaves the total number of eligible but unregistered households at 2,260,253, or 2.25 million households. That is about 7.5 million individuals. So this is the first category of persons about whom my clients are concerned. 2.25 million households who everyone accepts requires assistance to migrate into our digital future, but who for one reason or another have not registered for assistance with a set-top box. We've called those the missing millions in our heads of argument. The unknown variable, which the court debated with Mr. Marcus, which no party knows, is how many, if any, of those 2.25 million households have self-migrated by buying a new television which has decryption capability, by purchasing a set-top box out of their own resources, or whatever other means they've taken to continue to obtain free-to-air television. The minister speculates in her answering affidavit that many have self-migrated. She says one can see that there's the sight of digital satellite dishes in informal settlements when one goes past them, but that is about the extent of the effort that has been made to determine how many are still remain in that unknown variable. But we submit that speculation cannot be accepted on these papers, because my clients, who are here to represent those missing millions, put up independent evidence from the Television Audience Measurement Survey conducted by the Broadcast Research Council. You find that in my client's founding affidavit at pages 405 to 406 of the record, paragraphs 58 to 63. And all of that evidence was expressly confirmed on affidavit by the CEO of the Broadcast Research Council. That's in volume 8 at page 830. And none of that evidence was disputed by any of the respondents. So it's all common cause on the papers. And if one goes to volume 4, page 406 at paragraph 62, that evidence is as follows. The bottom line is that according to the Broadcast Research Council of South Africa, 36%, or more than a third of the population, or 5,747,823 households, rely entirely on analog terrestrial television services to access free-to-air television.
On that point, Mr. Ferreira, your protection time is up.
Thank you, Justice.
Colleagues may ask questions now. You may proceed.
So what we submit, Justices, is that we know that there are 2.25 million households who are eligible for assistance and who have not migrated. And we know that there are 5.7 million households in the country at large who are currently dependent on free-to-air signal for their free-to-air television. And once that is so, it simply cannot be correct that any significant part of the 2.25 million of eligible indigent households have managed to self-migrate in some way. It is simply inconceivable that that has occurred, because it's clear that the vast majority of them must remain within the 5.7 million households who are reliant on analog, but don't, and the remainder of that 5.7 million are those who rely on analog but don't qualify for assistance to obtain a set-top box because of their circumstances.
Isn't that speculation, Mr. Ferreira?
No, Justice Theron, it's not, because the contrary proposition, one would have to infer that there are 5.7 million households currently reliant on analog transmissions to watch their television, free-to-air television, but that number doesn't include the 2.25 indigent households who are eligible for assistance. And that is such an implausible and improbable proposition, Justice Theron, we submit it can be rejected on its face. Because where is that 5.7 million coming from if it excludes all of the indigent qualifying households who don't have a set-top box but do have a television? We submit it must include it.
Yeah. How do we know that more people have not self-migrated? Aren't we speculating about that also? That more people could not or did not?
Justice, there is no evidence about how many have self-migrated. No survey has been conducted. No attempt has been made to find out, but we submit that that is a problem for the minister and not a problem for the appellants. It was for the minister to attempt to determine how many people might have self-migrated, and we submit it was not an onerous duty for her to discharge. She could have discharged it either by conducting some form of survey or what we will get onto in some more detail is through a notice and comment process of consultation. That would have revealed how many people there remain in the 2.25 million. But I accept, Justice, there is no better, more rigorous direct evidence as to what the exact number of that missing variable is.
Yes, I suppose you will deal with it, Mr. Ferreira, but the minister says she got sufficient information and she expected to get information through the registration process.
Yes, Justice, our submission.
But you can deal with it at the appropriate time.
Yes, thank you, Justice. Just to tell you what the answer is, we say that would have been an answer if the registration process had been reasonable, properly conducted, and had afforded an opportunity for those in need to put their hands up. But on the facts, it didn't. So, Justices, one last point is that if there was any doubt about the devastating impact of this decision on audiences who rely on free-to-air television, that was put decisively to rest by the statement made by the SABC board after the hearing in the High Court. What one finds is that although the SABC is a respondent in this matter, it played no part in these proceedings. It didn't put up any evidence before this court. But after the hearing, its board woke up to the reality that if this date for switch off is going to be implemented, the SABC's audiences are going to be devastated. And they issued a press statement, which the court will find in pages 2322 to 2323.
Sorry, Mr. Ferreira, I'm sorry to interrupt you. Is that evidence on record? Is that evidence properly on record before us?
Yeah, Justices, it is one of the grounds of appeal that the High Court refused to admit that evidence when it was sought to be placed before it after the hearing in the High Court. So
why was that? Why was the High Court wrong?
We submit that the High Court was wrong because the test for the admission of further evidence is firstly whether it would prejudice any of the other parties, and secondly whether there was a proper explanation for the fact that the evidence was not placed before the court at the proper time. In other words, during the ordinary exchange of affidavits.
Well, you need not bother with the second, it's the first one. Why was it not prejudicial to the minister and ICASA and other parties?
It was not prejudicial because to the extent that they disagreed with any of the contents of that evidence, Justice Majid, they were expressly invited to deal with it in further affidavits and to address it, which invitation they ignored. And so when it comes to a question such as this one, which impacts on fundamental rights, we submit the court will not lightly turn its face from relevant evidence which is created or comes to light only after the hearing, in circumstances where all of the parties would have had the opportunity to answer to it had they chosen to do so. So we submit.
Yes, please finish.
No, Justice Majid, that was the submission.
If then, assuming we accept that the High Court was wrong, what about the second statement that SABC issued afterwards, almost in the form of a disclaimer? Yes. Should that not also be considered? And secondly, if so, what is the impact of that second statement by the SABC? Yes,
Justice Majid, we accept that it should be considered. We would submit that again, it's plain from its face that disclaimer was issued. Well, let me not speculate about what caused that disclaimer to be issued, but it doesn't retract any of the allegations of fact made in the first statement. It simply says this was not intended to be placed before the court and objects to its use for that purpose. But that's not to undermine the original statement, which BC, like ETV, is rightly concerned that ASO is going to devastate its audience figures.
Yes, thank you.
So, Justices, those are our submissions on what the extent of the impact will be. The response from the Minister, as Justice Turon has put to me, is one which appeals entirely to the registration process as an adequate and sufficient proxy for determining what that impact would be. And so there is a great deal of constitutional weight that needs to be lifted by that registration process. It needs to establish that it was a proper and permissible way for the Minister to assess the impact of the rights limitation that would follow from her decision to set ASO. What we say about that process is that it was manifestly unfit for that purpose. I'm going to be careful not to repeat anything that Mr. Marcus has already dealt with, but just to give you some sense of the chronology, what one finds, all of this is set out in the minister's answering affidavit in the section headed J in volume 9 from page 1057 and the annexes to that section. I don't need the court to go there, but I'll merely inform the court that all of these submissions are based on that very section of the minister's affidavit, so they can't be in dispute. What one finds is that between 2015 and 2020, that campaign primarily took the form of encouragement to registration through what is called izimbizo campaigns. You find that at volume 9, page 1059 to paragraphs 327 to 333. And one helpfully finds set out in the reports in the annexures the numbers of people that were reached through these campaigns. And as one would expect, when a campaign is based on face-to-face interactions with individuals, the numbers reached were in the thousands, not in the millions. And one can just look, for example, at page 1301, where the department records how many people were reached at a series of these campaigns. And you'll see the numbers are like 1,500, 2,500, 3,500. That's the nature of a face-to-face campaign. That's what they were achieving. And one finds also that during that time, the department was primarily targeting the 7 borderline provinces. In other words, excluding Gauteng and the Western Cape, the most populous provinces. One finds that in volume 9, page 1060, paragraph 328.
Mr. Ferreira.
Yes, Justice.
Can we attach any significance to the fact that only 1,000 people attended those Imbizo? If you look at the fact that it is a reality in society that the person who has attended that Imbizo would then, pass that information by word of mouth. In all fairness to the minister, should we take that into account or not?
Justice, thank you. I quite accept the proposition that any individual reached at one of these meetings would have or could have passed on the information received to any number of individuals. But even if one multiplies those numbers by 5 or 6, one would never get to the kinds of numbers one needs to get to in order to ensure that the millions who require assistance would become aware of it. And so I don't seek to cast aspersions on this form of communication, not at all. It's quite appropriate, but the submission is that it needs to be coupled with the kind of mass media campaign that the department then embarked upon in October 2021. It's quite clear that in order to reach the kinds of millions that you have to, you need to have some form of mass media campaign. And before I get to those mass media campaigns, so that's what happens between 2015 and February 2021. Then in February 2021, President Ramaphosa gives the State of the Nation address in which he announces that we're going to aim to turn off analog at the end of March 2022. In terms of communication and a mass registration campaign, between that February 2021 announcement and the October 2021 press statement, there is very little that occurs. There is no mass media campaign to encourage people to register. There is no ramping up of installations. There is a 7-month period, again, where very little is done to encourage people to register for assistance. And what one finds is that it is only after the 5th of October statement, which Mr. Marcus has dealt with, which is at page 213 to 214, that the Department of Communications seems to have woken up and realized that what is required is a mass media campaign. And what one finds about all of those mass media campaigns, Justices, they are in the answering affidavit from pages 1064 to 1067, and the rollout plan, campaigns are attached as annexures. What one finds is that the mass communication through the SABC, through Centec, through TV and radio registering commences on 11 October 2021. And the plans are plans for mass media campaigning for the following 4 months. In other words, October 21, November 21, December 21, and January 22. What we submit, justices, is that that is manifestly inadequate and insufficient in circumstances where the hard deadline for registration was the end of October 2022. It meant that all of the people reached by the mass media campaign conducted by the department to encourage them to register could not feasibly do so before the end of October deadline. And they would have known that if I don't manage to register by the end of October, or if I only receive this message in November, December, January, and so on, that the hard guillotine has already been missed. I now fall within that category of people who will lose access to free-to-air television, come what may, although if I register, the minister has promised I will get it within 3 to 6 months, I'll get it back. So
Mr. Ferreira, let's just focus on October. What was done specifically in October, insofar as the campaign communicating the call to those that qualify?
Yes. Justices, the most helpful place to view what was done, I think, is at page 1635. One can see these are the annexures. And they're sideways on my, I'm just going to rotate the view. What one finds here is a media buyout plan, which the Department of Communications prepared. And it involves the writing of a script to roll out on radio advertisements. It involves the purchase of television advertising time on all of the SABC channels. On ETV, one finds that at 1623. It finds commercial radio, community TV. So what one finds here is a very serious mass media communication plan rollout. It is a rollout of communication to say, we encourage you, if you are reliant on analog signal, to go digital. And what one finds when one looks at the dates is that this plan was developed after the minister announced the end of October deadline, obviously in a massive rush. And then from page 1629, there are a series of start and end dates for the broadcasting of these advertisements. And what one finds is that the earliest start date is the 11th of October. That's some 2 weeks before the hard guillotine cutoff. And going through, the campaign continues 18th of October, 11th of November. So our submission is that this is the kind of campaign that was necessary to inform indigent South Africans of what they needed to do. It could have been conducted at any time in the 7 months after the president made the announcement back in February 2021. But for reasons unknown, virtually nothing was done at that time. It was squandered. No communications were addressed to South Africans, and it all gets front-loaded or back-loaded right to the end of the process. And it comes at a time when it is simply too late to afford indigent South Africans in circumstances where we were in the midst of COVID lockdowns, the pandemic, all of the straitened circumstances that we were all living through, to say to people, you now have 2 weeks within which to gather your relevant documents, get to the post office and get yourself registered, failing which you're going to be cut off. And then I'm going to use that registration response to this campaign as my proxy, my only proxy for determining the impact of my decision. We submit that cannot pass constitutional muster. It simply is not responsive to the reality of the needs of the people who are being communicated with.
So your argument is that the period, number one, the deadline, the 3-week period was not sufficient. And those that were able to register, if they registered after the 31st, they face the prospect of being, you call it a TV blackout, because they won't get the STPs before the SAO.
Justice Mklantle, if as an indigent South African, you view one of these advertisements that were flighted in November of 2021, you will receive the message that I should register, but one will also know that I'm now beyond the cutoff date. And so whether I register or I don't register, I can expect that my TV is going to be cut off for at least 3 to 6 months. So yes, that's correct, Justice. We submitted was simply not sufficient to do it right at the end of the process. And there was never, and let me say it was exacerbated by the fact that there was never any consultation on this decision. And we have never been provided with any reason justifying the end of October deadline. Why was it necessary to put in a hard deadline for the end of October? We asked in the papers, and nobody has ever offered any reason other than that we need to get there quickly to this end destination of spectrum switch off. No reason of practicality, principle, or of any kind has ever been offered to justify that hard deadline.
Thank you. Justice Interhalter.
Mr. Ferreira, would you accept, as I think your argument seems to indicate, that the mass media campaign that was finally rolled out was adequate? And consequently, you can tell us what you think a reasonable period for that program was, but that essentially those who registered, let us say by the end of December, are those who were given a reasonable opportunity to do so. And that's the cohort that we should be examining for the purposes of looking after their interests. I asked the same question I asked of Mr. Marcus. At some point, those who don't put their hands up after a reasonable opportunity to do so, we can't continue to grant constitutional significance to their interests. Do you accept that proposition?
Yes, Justice Unterhalter, I quite accept that if an adequate registration campaign, which affords a fair opportunity to indigent households, has been conducted, that those who nonetheless don't register have no basis for constitutional complaint. It's like registering for a SASSA grant.
Yes, indeed. So would you equally accept that perhaps by the end of December of last year, anyone who reasonably needed an opportunity to register had been given that opportunity?
Justice, no, because of the imposition, the irrational and unreasonable imposition of the end of October as the deadline, because that tainted the whole process.
But is that proposition, I'm sorry to interrupt, but just in the interest of time, can that proposition be correct? That we need to, as it were, go back right to the beginning, as if no media campaign had ever been launched? Surely that is not what reasonableness requires. We have to say people, if they missed the deadline, but there are still adverts being run, would have understood that they can go ahead and register.
Yes, Justice. I do accept the premise of the proposition, but let me say that doesn't cure the illegality of the decision to determine ASO in the absence of an adequate assessment of impact.
No, it may not, but when it comes to remedy, assuming everything about your case is good, then we would at least know who are the class that we might need to protect. And it would be those who registered within whatever the reasonable time for response is when a proper campaign was launched. And we could determine who that number is, and we could see what would then be reasonable to allow a time for installation before switchover.
Yes, I accept that, Justice Unterhalter.
Yes, thank you.
Mr. Ferreira,
sorry,
can
I should just ask, do we actually know how many registered in that period? Or can we find out up to December?
Justice Unterhalter, we know how many registered up until I think it's the 10th of March, 2021, which is when the minister put up her supplementary affidavit.
Yes.
The number was some 250,000 households after the end October deadline and before the 10th of March of this year.
Yes, thank you.
Yeah, Mr. Ferreira, can I ask you about this question that you're dealing with now, the question of a needs assessment? Now, do you make the submission that the reliance on registration itself is inadequate? Do you make that submission on the basis of a rationality review or of a proper PAJA review?
Justice Majid, I'm going to address this question in quite some detail.
Oh, sorry, the third one is, doesn't it matter?
Justice, we submit, can I just take a moment to see whether I might have been about to move on to this point. Let me just locate myself in the, Justice, let me address it as you've asked the question now. It is very important, as the court debated with Mr. Marcus, to understand properly the nature of the power that was exercised. And
yes, because that will affect the threshold of consultations that was required. We know that in a rationality inquiry, the threshold is much lower. when it comes to the question whether there's adequate consultation with affected parties.
Yes, Justice Majid, except for what we submit is that in this case, it doesn't matter because the decision was unlawful for a failure to consult on both tests. And let me explain briefly why before saying so in some more detail. In this case, the minister there's quite a bit of confusion about the source of the minister's power to set the ASO on the part of the minister, and her version has changed in relation to this question. The problem is that it's either an administrative decision, in which case the minister was, we submit, duty bound to consult in terms of Section 4 of PADGA, which requires an administrator, where she takes a decision where there's administrative action which materially and adversely affects the rights of the public, to either hold a public inquiry or to conduct a notice and comment process. It's either administrative, and that was the duty, or we submitted was a policy decision. And if it was a policy decision, what I will submit to you now, Justices, is that the true source of the power to take that policy decision is not some free-floating constitutional policy-making decision. It could only be Section 3(1) of the Electronic Communications Act. And once that is so, Section 3 sub 5 sub B of the Electronic Communications Act required the minister to publish the fact that she was considering taking the decision and to consult in relation to that decision. And so she's on the horns of a dilemma. Either she had to consult in terms of PADGA if it was administrative, or she had to consult in terms of Section 3 sub 5 of the Electronic Communications Act if it was policy. And it's common cause on these papers that she did not consult. So Justice Majid, may I dig into that submission in a little bit more detail?
Sorry, if you say it's common cause on the papers that she did not consult, the minister's case, as I understand the heads of argument for the minister, is that she did consult. She refers to a number of meetings where ETV was present. I know your clients weren't there, but ETV and other role players were there. Do you say that is not proper consultation or it's inadequate?
Justice Majid, there are two answers. In the first instance, it was not adequate consultation because it did not involve the public, and in particular, highly interested and expert organizations such as my clients. We were never invited to or given notice of those consultations. That was a process of engagement with primarily broadcasters and Centec. It was not a public consultation process of any kind. Number one, it was inadequate for that reason. And number two, what is common cause even on ETV's version is that none of those consultations involved the particular question of the date that was being contemplated for ASO. And in none of those consultations did the minister put to the consultees two important things. Number one, I'm thinking about making the end of March the end of the date for switch off. And number two, I'm thinking of imposing a hard deadline at the end of October for people to register. And so those consultations were inadequate for those reasons, but also because they weren't really truly public consultations. It's established on the papers that my clients were not involved, despite having attempted to make submissions on various aspects of analog switch off throughout the years before. It was a closed shop, as it were. Industry bodies were brought in to be consulted. And that doesn't comply with Section 3 sub 5, and it doesn't comply with Section 4 of PADGA.
Mr. Ferreira, just a last follow-up on that. If we for the moment postulate a hypothesis that it is in fact a rationality inquiry with a fairly low threshold, as is clear in our law, why do you say your clients, MMA and SOS, are affected parties? What make them affected parties that require to be consulted with by the minister on a rationality threshold?
Justice Majid, let me just say that there are two possible thresholds for review in relation to rationality. The one that you're putting to me is the general duty to consult in particular circumstances of the kind that this court considered in Albert and the Supreme Court of Appeal considered in Scalabrini. My submission in relation to that more difficult case is that my clients were plainly expert independent bodies advocating for the public interest on this area. I'll take the court to the pleadings on that in due course. And that on the Albert test, it could never be rational to set a date for ASO without considering their views and, more importantly, the views of the public. But Justice Majid, there's an easier line. If I'm correct that a policy decision of this nature falls within Section 3.1 of the ECA, Section 3.5 of the ECA imposes a different legality requirement. It's not a question of Albert where there's no statutory duty to consult. Section 3.5 of the ECA creates an express duty to consult in circumstances where policy addressing the issues contained in Section 3.1 applies. And so one needn't get into those difficult questions of, is this an Albert type of case? All one needs to do is look and say, was this policy emanating from Section 3(1) of the ECA? If so, the statute creates a duty to consult with the public and with interested parties expressly, and that was never done. And so it's a much easier, it's a legality review, so one would call it rationality, but it's not substantive rationality, it's really legality. Justice, may I briefly develop that submission in relation to the potential sources that the minister has identified that might be the source of her power to make this decision. Initially, as Mr. Marcus said, she pointed to the 2012 digital migration regulations. The court will find the relevant regulation in volume 3 at page 290. And what one finds there is a reference to the date for the commencement of dual illumination, as well as the date for the final switch off of analog will be published by the minister in the Gazette. And as Justice Theron put to Mr. Marcus, on its face, that provision doesn't really seem to confer a power to make a decision. It simply records that the decision will be made and published by the minister in the Gazette. And quite importantly, these regulations which we're looking at are regulations made by ICASA under the Electronic Communications Act. They're not regulations made by the minister. So if this is the source, it's a little bit odd because what ICASA is doing is making delegated legislation which confers upon the minister the power to take a decision. That was the minister's first answer in her answering affidavit about where the source of the power came from. She now wants to run away from that answer, and the reasons are obvious, because if this is the source of the power, then it's obviously an administrative decision to determine the date. That's quite clear because it would constitute the implementation of legislation, delegated legislation, namely the ICASA regs. And if one reads, for example, this court's decision in SAFU, volume 2000, volume 1, SA1, a judgment of this court, especially paragraphs 139 to 147 and 142, one will see that this kind of implementation of legislation and the exercise of a power which affects rights in terms of conferred in delegated legislation, that's classic administrative action, and that seems uncontroversial. And if that's correct, I've already submitted, the minister was obliged to follow the notice and comment process in terms of Section 4 of PAJA. Justice Theron, as you put to Mr. Marcus, what counts against the finding that those regulations are the source of the power is that Regulation 3.1 doesn't in terms seem to confer a power to make a decision. It merely seems to record that it will be gazetted. And when one looks at the preamble to those regulations, one sees that ICASA states that in making the regulations, it considered the broadcasting digital migration policy of 2012. And so what it seems to be doing here is reflecting the fact that in the 2012 policy, it was stated that the decision is for the minister to make. The court will find that in the preamble at page 286. So if that's correct, then it seems that the power to determine the date flows not from the regulations, but from the policy. So this is option 2, Justices. If the power comes from the policy, and this is what seems to have been the minister's understanding when she exercised the power, because if one goes to volume 21, page 2234, that is the gazetted decision determining the date of switch off. And what one finds is that the minister says that she makes the determination, open quotes, under paragraph 3.3.1 of the broadcasting digital migration policy published in government notice, etc., under 2008 as amended. So the minister at the time of taking the decision understood the source of her power to take the decision to be the policy. If I can just ask the court to have a look at the policy, the court will find that in volume 3 at page 305. That is the inserted paragraph 3.3.1 of the policy. It records government is committed to a successful migration. And then it says government has decided that the digital signal should be switched on a date to be determined by the minister in consultation with cabinet. The date for the final switch off of the analog signal will similarly be announced. It says, but I think one must read there, will similarly be determined in consultation with cabinet and announced be announced by the minister in consultation with cabinet. So then it looks like it's really the digital migration policy as amended, which is the source of the power. And here's where the problem for the minister arises. If that is the source of the power, and that power confers upon the minister the power to set a date, which is a policy decision, as the minister strenuously contends, then the only possible source of that power can be section 3 sub 1 of the Electronic Communications Act. And one sees that very clearly, because the minister is at great pains to say in her heads of argument that this is the same kind of power that was in issue in the electronic media network case of 2017, where ETV similarly sought to review a policy of encryption. They say it's the same kind of power. It's a section 85 of the Constitution power, but they've only told you half of what the court found in that case. It's not just the section 85 sub 2 of the Constitution power. It's a power of section 85 sub 2, which is given effect to by section 3 sub 1 of the Electronic Communications Act. And what's quite clear is that if this is a policy decision, we don't accept it is a policy decision, we think it's administrative, but if it's a policy decision, it's a policy decision of the kind that falls within section 3 sub 1 of the ECA. Here's why. That section says, the minister may make policies on matters of national policy applicable to the ICT sector. So that's plainly where we are. National policy applicable to the ICT sector in relation to A, the radio frequency spectrum, B, universal service and access policy, C, the Republic's obligations and undertakings under bilateral, multilateral, international treaties and conventions, D, the application of new technologies pertaining to electronic communication services, F, the promotion of universal service and electronic communication services in underserviced areas, and then the general catch-all. So this is the statutory section that covers the field in which the minister now comes and tells us that she is making policy. Once that is so, when making that kind of policy, she has to comply with section 3 sub 5. And section 3 sub 5 says, when issuing a policy under sub 1 or a policy direction under sub 2, that's sub 1 is what I just read to the court, the minister must, in order to obtain the views of interested persons, publish the text of such policy or policy direction by notice in the Gazette, declaring his or her intention to issue the policy or policy direction, and inviting interested persons to submit written submissions in relation to the policy or policy direction in the manner specified in not less than 30 days. So, and we accept, as this court found per Justice Mogoeng in the electronic media network case, we accept that the original source of that statutory power is section 85 sub 2b of the Constitution. Section 85 sub 2b gives that original policy-making power, and it's given effect to in section 3 of the ECA. But what section 85 sub 2b does not do is it does not allow the minister to make policy which falls within section 3.1 of the Electronic Communications Act, but without complying with section 3 sub 5. That could never be, because then that would fundamentally subvert Parliament's intent in setting constraints on how the minister must exercise a policy-making power when that power relates to radio frequency spectrum. And that's what the court has held.
On that score, Mr. Ferreira, your allocated time is up. How much more time do you need?
Justice, I think I can get there in 10 minutes, and I'll do my best. So we submit that the dilemma impales the minister in relation to the legality of the decision. She had a duty to consult one way or the other, either under PAJA or under section 3.5. May I just round out the submission on section 3.5 of the ECA by recording and acknowledging quite readily that we did not plead that case in the High Court. That case is not made out in our heads of argument. And I became alive to that point last night in the course of my preparations for today's hearings. I did alert my opponents to it, but it's not pleaded. I just want to make the submission that this is the kind of point which the court may take cognizance of, notwithstanding the fact that it does not appear anywhere in the pleadings or the heads of argument. This court held in Barkhazen versus Napier, paragraph 39, and then again, and this is what I'll refer the court to in Sarovitz versus Maritz, NO and another, a 2015 volume 4 SA 491 decision at paragraph 30, that in deciding a point of law of this nature, the court will be guided by, firstly, is it a point of law and not one of fact? We submit that it is, because the facts in relation to absence of consultation were squarely pleaded, and it's common cause there was no notice and comment process in relation to the decision to set the date. It must be covered by the pleadings. We submit that it was covered by the pleadings for that reason. And finally, we submit there is no prejudice to the other party. And in fact, it would not be permissible for this court to decide the issue of the source of the minister's power on the basis of a mistaken understanding of that source, which was shared by the parties. And especially in this case, where the minister has flip-flopped so many times about what she understands to be the source of her powers, it's quite understandable that the point was not properly pleaded out in the High Court. So, Justices, there was a failure to give notice and a failure to consult. We submit that the court can decide that without deciding whether this is an Albert or Similania case, because of section 3 sub 5 of the ECA. But if this court thinks that it is an Albert, thinks that for some reason section 3 sub 5 of the Electronic Communications Act doesn't apply, we submit that on Albert and Similania, so too was this a case where procedural rationality required the minister to, at the very least, consult with my clients and the public. Justice Majid, you asked where the duty to consult with specialized expert bodies in this area comes from. If I could just refer the court to the judgment of the SCA in the Scalabrini matter. It's Minister of Home Affairs v. Scalabrini and others, 2013, volume 6, SA 421, SCA, where the Supreme Court of Appeal held that the failure to consult expert organizations who operate in the public interest in a particular sphere may render a decision irrational on the procedural irrationality test. And we submit for the reasons given in our heads. This is the kind of case like Similani, where there was a duty to consider relevant material. One way to obtain that material would have been through a notice and comment process, and that was not done. Justices, my second from last point was to deal a bit with the facts in relation to how long can those who have already registered expect to wait before their installations occur. And that applies to all those we know who have already registered as at 10 March and anyone who registers thereafter. This issue determines how long those people will be plunged into television darkness for on the current rates of installation. What we see looking at what the minister tells us, and the last update we had was before the High Court in a supplementary affidavit on the first day of hearing, is that from 10 March 2022, a total, from the commencement of the process, until 10 March 2022, about 660,000 installations occurred. That was about 362 per day over the course of the whole period. Right at the end of the period, when the minister really ramped up her installations process in order to impress the High Court, it speeded up, and they managed to install 103,000 between November and March 2022. The best rate that we have on record is about 1,401 installations per day. Now, when one takes 1,401 installations per day and applies it to the numbers of those who still need to be installed, which is about 768,000 installations that needed to be done, and one works it out at 1,401 per day, one doesn't regrettably get to the end of June 2022. One doesn't either get to the end of September 2022. What one finds is that it will take slightly more than 2 years to conduct those installations at that rate of installation. And so what we say,
Mr. Ferreira, I'm sorry to interrupt you. Something has just occurred to me that I wanted to put to you earlier when you raised this very interesting section 3.1 of the ECA point and section 3.5 with it. When I read your heads, and it just occurred to me now, your heads is premised on three broad grounds. Firstly, there's the section 16 point, which you haven't covered because Mr. Marcus has dealt with it. Secondly, there's the question of, let me just have a look, the retrogressive measure, which Mr. Marcus also dealt with, but then you dealt with irrationality. Your entire heads, as I understand it, is premised on a rationality argument, not a Paja argument. I understand the ECA point is new, but it seems to me your heads deal with rationality only, and it deals so in the context of DA versus the president, the Similani case. Now, why is that? Have you changed tack? Are you no longer saying this is a rationality case? Are you saying this is a Paja case?
No, Justice Majid. Our position was always that we thought that the decision was administrative, but that it didn't matter because it failed even under the more stringent rationality review. And we don't abandon that position.
I see.
In particular, the Similani point on a failure to take into account considerations, all of my submissions on the inadequacies of the registration process.
Yes, I understand that. Yeah.
It was in that context of that argument. So
I wanted to clear that up. Thank you. Thank you.
Thank you, Justice. So Justices, in relation...
I'm sorry, Mr. Ferreira, while we're on the Electronic Communications Act and Section 3, I understand that your client's relying on Section 3, subsection 5. That subsection says, when issuing a policy under subsection 2.
Justice, it says when issuing a policy under subsection 1 or a policy direction under subsection 2.
Where does it say, sorry, when issuing a policy under subsection 1?
Justice, I wonder if we might be looking at different versions of the statute. I do have the ECA open in front of me, but let me just double check on duties that I
if it helps, Mr. Ferreira, that subsection 5 was substituted in 2014 by section 3D of Act 1 of 2014. I think that's the latest. That's the latest version of it.
On my version reflects that 2014 amendment.
So the mistake might be on my part. I might have an older version of the Act.
I hope so.
My apologies.
Can I follow up on that, Mr. Ferreira, just for absolute clarity? Does your section 3.5 as amended in 2014 read, quote, when issuing a policy under subsection 1 or a policy direction under subsection 2, the minister must do certain things? Is that
correct, Justice?
Thank you. Sorry for the interruption. Thank you.
Not at all. Justices, and just because this is the stuff that advocacy nightmares are made of, if I look at JUTA, yes, it looks like that is the most up-to-date version, Justice Rowe. Thank you.
Thank you.
So, Justices, what we say in relation to the slow rates of installation is we are surprised by the lack of an update from the Minister to this court, despite being expressly invited to update on the rate of installations in my client's application for leave to appeal. We are surprised by the refusal to agree to provide subsequent reports to the High Court and to this court in accordance with the reporting relief that we have sought. Because if one is so confident that these installations can happen within that period of time, and if anyone is to have assurance that the High Court order is to be complied with, we would have thought the only reasonable way would be for the Minister to come and tell the court how installations are going and how far we are going and how we're getting there. So we submit that the refusal to come and provide a report and the failure to update this court, at the very least, gives rise to a justified concern that installations are not happening at anything like the rates which the Minister anticipated that they would be able to happen when she filed her supplementary in the High Court.
Would there be an objection on the part of the applicants if the minister is asked to provide a report at this late stage by the court in the form of an affidavit, just to update the court.
No, Justice, I don't think we could ever object to that in light of our express request for the reporting relief, which essentially seeks the same thing. And I don't think we would object either to a further affidavit coming before the court's judgment, provided there's an opportunity to respond to it.
Yes, thank you.
Justices, there's only one small submission that remains, and that is in relation to
Before you get to that, Mr. Ferreira, you've submitted that it would take approximately 2 years for the minister to reach everyone. The question that arises then on my side is it pertains to the available spectrum and the impact of that on the telecommunications companies. Because 2 years is a long time, and it does not seem to be in dispute that they need that spectrum in order to also make sure that the dropped calls, etc., do not happen. So if we were to be on your side or with you on that perhaps an extension is necessary. 2 years is a long time. And what would the impact of that be on the telecommunications companies and the public as well who use those services?
Yes, thank you, Justice. We do not regard the 2 years as a number which is frozen in time. That, of course, is a dynamic figure which the minister has the power to accelerate by increasing rates of installation. And so we don't move from the factual premise that the best currently achieved rates will take 2 years for everyone to be installed to a request for a further delay of 2 years. That's not what we ask for. The only submission I can make is that whatever additional delay this court regards as appropriate, it is in the minister's power to ensure that in that time, sufficient numbers of registered South Africans could be installed by ramping up rates of installation. And the submission was simply that it's for the minister to come and tell the court whether that is being achieved or how it can be achieved. So we don't, I wasn't seeking to sneak in a request for a further 2 years beyond the June deadline.
Mr. Ferreira, I'm sorry, can I just take you back to the question of remedy, which you may be going to deal with anyway, but I don't understand you to be, assuming we were with you on the question of the failure of notice and comment that should have taken place but didn't. I don't understand you to be saying that that needs to be rerun. Or are you saying that that must take place? Because if we're to find a just and equitable remedy, would it not, based on some of the submissions you made earlier to my questions, be more reasonable to say, well, if approximately 500 million, as I think 500,000 rather, registered up to March, you take that figure as being the figure where a reasonable opportunity was given for registration, and no date would ever have gone beyond that anyway, and then leave it to the minister to make sure that she installs those set-top boxes for those persons. And until that has happened, then switch off can't occur. And then the minister has all the incentives in the world to make sure that all of those people are looked after. Isn't that a simple, clean remedy? On the assumption that you're correct, of course, but just thinking practically about remedy and not having indeterminate time periods and reporting and all the time and cost that that involves.
Yes, thank you, Justice Untohalter. No, we would submit that the notice and comment process must be rerun. That need not derail the remainder of the whatever remedy the court needs to conduct, because under Section 3.5 of the ECA, what one is looking at is a 30-day process. So that is going to be fall easily within, if it is conducted swiftly, whatever time period of pushing out the court may be contemplating in relation to just and equitable remedy. The reason we say it can't be dispensed with, Justice Untohalter, is because the purpose of that notice and comment process in this matter has been subverted in a way that means that the decision maker and the parties and this court sit without access to a critical fact, which is what proportion of that 2.25 million have managed to self-migrate or in some other way or to register.
But why does that matter? If you accept the proposition that let's take 3 months up to the end of December or the end of January was a reasonable time for anyone to register. You may not accept that proposition, but just on that premise for a moment, then we don't run processes just for the sake of doing them. If that period is an adequate period to allow people to register, why run the process again of notice and comment just to arrive at the conclusion that the right figure was somewhere between 2 and 3 months?
Yes. Justice, my only submission is that one cannot, based on the defective process which was followed, rely on the numbers who have registered. And so we would dispute the premise, which is that given the end of October deadline, given the backloading of all of the communications to the end of the process, given the lack of public confidence in the installation and registration process that was engendered by that, we submit that one cannot place confidence on the process that was run, and that a notice and comment process is a better and more accurate way for the minister to gauge what the true facts are.
So your contention is that notice and comment must be done again. Another period of time must be allowed, in addition to all the time that has already gone by, for further registrations. And all of that time would have to then carry on, and any additional people who register must then be accommodated, and this thing just gets pushed on and on and on.
No, Justice. With respect, it's not. This court's job is easier. This court doesn't have to solve all of those problems. And this was to take me on to my final submission on remedy. All that this court has to do is review the minister's determination of the date of ASO. And it is then for the minister, and to make clear what the grounds of review were, and in particular, that it was the failure to consult properly, to conduct and a failure to, as a result of the failure to consult, to take into account the extent of the impact on expression rights. And it's then for the minister to conduct a fresh process. That process doesn't need to take years or even months. It can be a 30-day notice and comment process. Based, depending on what she receives, she may then decide, well, everybody who needs assistance has stuck their hand up. Nobody is objecting to my proposed determination of analog switch off, and so we can push ahead with a 2 or 3 month process. So really for this court is just to find that the determination of ASO was unlawful for the reasons we give, and to remit it to the minister to do afresh in the light of the court's judgment. And that submission, Justices, also I submit demonstrates that the great deal of noise which is made by the respondents about the declaratory relief being interdicts dressed up as declarators, all of that noise is really quite overblown with respect, because what one needs to remember is that when this application was launched, one had a minister who was pretending not to have taken any decision. And so both ETV and my clients were not clear that they could bring a review, because it wasn't clear that any decision had been made. These letters of demand were being sent. The minister was failing to respond to them. And so out of an abundance of caution, they brought an application to review any decision to the extent it had been made, but also seeking declarators that before the decision could be made, there must be consultation, there must be a reasonable process to register people. So normally one would find those declarators would just be the grounds of review which are upheld. And we would submit that the same outcome can be achieved by this court simply by granting the review and making clear that the failure to consult is the basis upon which the review was upheld. And so the declarators... Yes.
Your additional time is way up now.
Thank you.
In fact, we've exceeded it by 5 minutes.
Justice, I'm very grateful to the court for the indulgence, and I will stop.
Is there anything else I don't want you to stop you, but I'm looking at the time. We had covered everything, and maybe you still have time for a reply.
Justice,
If there's anything that's outstanding, you could touch it on that stage.
No, thank you, Justice. That concludes my submissions. Thank you.
Thank you so
Mr.
much.
Nhlanhla, I'm so sorry. I have a question for Mr. Ferreira. It relates to the submissions made at paragraph 141 of the Minister's Heads of Argument, and it corresponds to the evidence that is at volume 9, pages 991 and following. Briefly, what the Minister says there is that she had discussions about the proposed date. This relates to your submissions, Mr. Ferreira, that the Minister had failed to have discussions about the proposed date of the switch off.
I'm sorry, Justice, I overlooked that. I must let me withdraw that submission and fall back on the only submission which I think is justified on those facts, which is that one can't conduct a public consultation with ETV and Centec and Mnet. One has to do it with the public and with NGOs like my clients too.
Okay, so the submission would then relate just to your clients that the Minister failed to consult with media monitoring.
And I think it's common cause what I should have said and what I think is the correct submission, that there was never any consultation on the choice of the end of October deadline.
Thank you, Mr. Ferreira. Thank you, Justice Nhlanhla.
Thank you, Mr. Ferreira. We will now take a lunch adjournment until 2:15.
Court will adjourn until 2:15. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 2:15. Should you exit, you may use the same link to rejoin the hearing.
Thank you. Hi, Tokoso.
Justice Nhlanhla, can you mute yourself?